you're going to be talking Social Security too today.
That's right.
As well. So, and then we have, of course, Joe Stanley of Stanley Law. And Joe, how are you doing in your corner of the world today?
Fabulous.
All right. All right. Well, without further ado, we'll give a little bit of time here as people hop on. Technology being what it is, Facebook wants to just buffer and not get me to the page I need to get. So if you have questions, I'm going to keep trying to get in there and take a look. And if not, maybe Megan, I don't know, do you have your cell phone handy, Megan, or no?
I do.
So we may ask you, Megan, if I can't get in here and it just won't let me in, we may ask you to hop on there to be able to kind of just watch from time to time. If
sure,
we have
that
questions.
may challenge my Facebook abilities, but
I know, putting it to the test.
Yeah.
Hey, just when you thought you were done growing, I asked you to do something more technology. All right. So in the meantime, let me turn this over to Joe Stanley, and then we'll take it from there.
Well, thank you, Angela. Thank you, Megan. And I'm sure everyone will be thanking you even more after you finish to update them on the vagaries and the intricacies and the difficulties of both the workers' compensation and the Social Security disability system, which, at least from the pandemic situation, both of those courts have continued to operate regularly in terms of having their hearings. So unlike the Supreme Court, where most of our personal injury cases are going, those cases continue to go, they continue to be resolved. Just as an update from what we do, the personal injury aspect of the practice, the courts are functioning. I actually had a virtual conference today, but only motions and legal arguments are being held, and they're all being held virtually. They are contemplating, and I use that word loosely, how they're going to conduct in-person hearings, trials in the future, which of course is going to be problematic in the social distancing world, but we will keep everyone posted. We want trials and hearings to go forward as soon as possible, because that's how we resolve cases. So we'll keep our fingers crossed. Everybody continue to social distance and be safe and healthy, and then the courts will hopefully open even sooner. So Megan, take it away.
Okay, take it away. Okay, so let me just give you my screen first.
And I was able to get in, so I'm in and can see any comments and questions.
All right, so let me.
So then, yeah, all the way to the left, Megan, and just hit from beginning there. There you go.
There we go. Okay.
All set.
So, right, so I did one of these before, if anybody's ever heard that, but I'll kind of just go back through. It's always good to hear the basics of these areas of law, because even people that are dealing with them every day, it's helpful to recap, okay? So basically, I don't want to see it. Okay. So let me start really basically with workers' comp. Workers' comp is a state law, right? So New York State has a law that governs your relationship with your employer when you're hurt at work. It has two benefits that are covered: medical and lost wages. I'll get into some of the details about that. But so the first thing I guess I want to show you is, what do you have to do if you get hurt to be covered, okay? You have to give notice to your employer within 30 days. So the statute says you have to give the notice in writing, but it almost immediately with case law forgives that if it's difficult to do. They want to make sure the employer cannot prevent you from properly giving notice. So generally speaking, giving notice in verbally is enough, but you have to make sure you tell someone other than a coworker. So a lot of times employees are afraid to give notice to their employer because they're afraid they're going to get fired or have recourse against them just because it happened. It's critical that you not tell just, your friend at work and try to allege later that you gave notice. That's not notice. So notice is telling a supervisor, telling somebody in human resources, but you should do it in writing and make sure they know it. So even an email is enough. Second, you have to file a claim with the Workers' Compensation Board, so the Workers' Compensation Board is a state agency that was created to keep track of these cases and to provide a court system. They didn't want to clog up the Supreme Court that Joe works in with all these claims because there's so many of them. So they have their own court. It's New York State Workers' Comp Board. you have to file a claim with them within 2 years of the injury happening. That's done by a simple form called a C3 form. It's a 2-page form you fill out and you file with the board. You can do that online. The workers' comp board is pretty easy to find. It's wcb.ny.gov, and we have information on that.
When we're talking about that, filing that form can be very important, the information you put in it though, right, Megan?
That's absolutely right. It's especially true if you have a case like Joe, if it overlaps. So if you get hurt at work and you also have a negligence claim, one thing we are very careful in our office about because of Joe's prompting and because of the importance of it, is that that file and the description of the way the injury happened is accurate and does not hurt you, meaning does not hurt your claim either in workers' comp or if it happens to be a case where you have both a workers' comp claim and a negligence action, that we don't hurt each other.
How about the description of the injury also? Is that something, even if it's not a personal injury claim, can you be penalized if you don't put everything in there?
Yes, totally. Very good point. So, two things. One is, so the form asks you 2 critical questions. One is, how did the injury happen? 2 is, what is the injury? So what did you injure? You have 2 years to make not just a claim that it happened, but you have 2 years to claim every part of the body that you may have injured. Okay, so Joe is absolutely right that if you don't, if you just say, I hurt my back, but you really hurt your back, your hip, your knee, and your elbow, if 2 years passes and it only said the back, you're out of luck on claiming the others. That's a little bit of an overstatement if your doctors are treating those parts of the body and they're billing comp and comp is covering it. You'll have a couple of arguments to make to try to salvage that, but there's no reason to do that. If you put it in your form initially, what I always tell people and what we always do in our office is, if there is any pain at all there, just put the part of the body in. Don't worry about medical diagnoses. You don't have to say herniated disc. You have to say back and leg and arm and knee and hand. When in doubt, you put everything in. If those things go away, that's great. But if they persist and you did not mention them, you could lose coverage.
Megan, does that also hold true in the reverse? If you didn't realize you hurt something, and sometimes, that things they might not emanate until further down the road. You still have up to that 2-year time frame.
Yeah, that's a really good point too. In fact, that points out one of the many defects in comp, which I don't think were intentional. So there's 2 types of claims in comp. One's an accident. One's what we call an occupational disease. It's a repetitive injury that occurs slowly over time. It's crazy, but if it's a repetitive injury that occurs over time, you actually get 2 years from the date you first knew that particular condition was caused by your injury. Yet in an accident, you don't. So you'll see comp lawyers that represent insurance companies, they will try to get a claim established as an accident when it really was a repetitive injury claim for exactly this reason. When it's an accident, you only have 2 years from that date to claim any diagnosed condition. That is to say, any diagnosed condition that occurred in the accident. If it's a consequential condition, which means, let's say I hurt my knee and I have a knee replacement and I have multiple surgeries on my knee and I'm limping for 3 years. If my back starts to hurt me 2 years later, we call that a consequential injury. It did not happen as of the date of the accident, but developed slowly later because of the first accident. You have 2 years from the first knowledge of a consequential injury, but you do not have 2 years from a first knowledge if it was caused by the original accident. You have to claim all injuries within 2 years if they actually were caused by the accident at the beginning. So
now, Megan, before you go on to the next point, can you give some background? This isn't your first rodeo, right? I mean,
Yeah, so I've been doing workers' comp full time since 1994.
Wow.
Yeah, so right. So if I don't know everything about it by now, I need to go to the doctor.
Except except like you said, before we started today, you always have your eyes wide open because the laws are always changing and pivoting, right?
Yeah, so in fact, there was just a change recently that happened during COVID. Some case law came out and, even not being aware of that case law for 2 weeks could cause a problem, and almost did for me, but didn't, because
this is a novice asking the question, right? Because
Sure.
I'm on the outside looking in here, like so many of the people watching today. And how do you know that? So you've got this limited window. You could have some detriment to cases if you didn't know the change in that law. And yet, how are you as a lawyer? How are you notified when a law?
You're not really directly notified. You have to pay attention. But there's a lot of resources for that. So there, you can follow the case law of, you can research it first of all on Westlaw, on the different forms of research, and there's different organizations and access to cases that are coming out. I'm on a internet, by email group of attorneys that specialize in representing workers' compensation claimants, and we stay in touch with each other. And there's several of them that just we'll send out little summaries of cases that have just come out, the topics that they're on, give you the link, and we can follow that.
So you have to have, so in other words, you have to have enterprise. I mean, you got to keep your curiosity up. You got to have enterprise. You got to stay on your toes.
Yeah, and also when you
hit autopilot in workers' comp, it's not a good deal.
No, right. So and I mean, a lot of the ways the important thing about getting somebody that specializes in anything today is that we're literally doing it all day long in front of the judges with other attorneys making these arguments, and judges will ask the lawyers and the lawyers will ask the judges. As these cases come out, they start getting applied, and you see it being applied sometimes even contemporaneously with you. We'll have conversations, which I had last week, with a judge saying, hey, in light of this case that just came out, how do you see this? How are you applying it? And the judge will even say, we're not really sure if this is going to hold, but it's my understanding that the way we're going to be applying this is X. So
and now, and you said in front of judges, et cetera, for quite some time, Megan, you told me that, and I think we shared it with viewers before, your area of law, your area of dedicated law has been kind of practicing this virtual mode for a while anyway, right?
Yeah, yes, that's true. For gosh, I don't even know how many years now, but at least minimally 3 years, 2 years, I should say, we've been doing virtual hearings or capable of it. So you had the option of either going and sitting in front of the judge or appearing like we are right now on basically it wasn't Zoom, it's the state's own computer system, but we can appear. So yeah, so right. So I would be appearing right now just the way we are right now if Joe was the judge and you and I were the attorneys, and our clients would either appear or not appear. They can choose either to do it virtually or by phone or just not appear. So yeah, we've been able to
You lose.
Yeah. Oh, I lose. All right. I should hope you find in favor of the claimant at all costs. The claimant being the injured worker, right?
Yes, that's correct.
Yeah.
All right, Megan, I'll let you get back to your slides.
Okay.
But there's just
just
interesting from a layperson's perspective how the inner workings of it all goes.
Yeah, no, that's good. That's good. Good questions for sure. So right. So we were just saying you got to give notice within 30 days. You have to file a claim within 2 years. It is important how you fill it out. We can help you do that. 3, your doctors must actually say that the injuries or diagnosed conditions you have were caused by that either accident or illness or repetitive work over time, or any exposure you might have had at work. And then we have overcome any controversies, because there are a lot of controversies. One thing I'll just note for you is the last time we did this, we were kind of either early or deep into COVID. Everybody was warm and friendly during that. Already we've seen that wane, meaning the insurance company lawyers are taking positions already that the obligation to look for work is no longer forgiven. That's not like a firm statement, but the presumption is, hey, we're coming out of this. Has your client been looking for work? Are they going to the doctor? We've already had people that are the carriers are starting to try to cut their payments because they haven't been to the doctor. It's not working quite yet, but might as well be, right? So I've already told 2 people today to call their doctors. They were kind of assuming because of COVID that they couldn't go to the doctor and weren't clear on the medicine options, right? So that most doctors are seeing people either in person or still by video. So it's important to continue to go, especially if you're being paid lost wages. What's covered? There's 2 benefits in comp. Basically, medical bills are paid and your lost wages are paid. Medical bills, 100% of the bills are paid. If you're ever getting a request for a co-payment, that means
let's talk about that's at the workers' compensation rate, though. So
true.
If the client allows if it's not billed properly, that can present. If it's billed to Medicare or private health insurance, that could present issues.
Yeah. So that's very important. So first of all, you have to go to a doctor that accepts comp. What does that mean? Not just they in a whim, they accept comp. They accept comp, and they are authorized by the Workers' Comp Board to treat comp patients. So when you check into your doctor and they ask you for insurance, you should give them workers' comp. And if they say, okay, what else do you have? You really should resist. You want to have that conversation right away, because it's not something where the doctor should just choose to bill who they prefer to bill. So if you walk in and you say, Travelers is my comp carrier, Blue Cross Blue Shield, or Excelis is my private, that really shouldn't be at the end of the conversation. It should be, this is comp, you have to bill comp. The medical doctors have to bill, the providers have to bill comp within 90 days from the end of the month where the treatment took place. If they don't, they are forever barred from getting paid for that bill. That's surgery, that's anything. So even if we win the case, everything's covered, that's not covered. The doctor will not be paid.
But if it is covered, the doctor can't come after you.
That's correct. So if the doctor didn't bill it right and your comp claim is covered, there's comp law forbids them from pursuing payment from you directly. So you're helping them and you by making sure everybody's clear this is comp right at the beginning, and make sure they bill properly.
And if they, of course, everybody needs to understand is that workers' comp pays substantially less than regular health insurance and Medicare. And so there is an incentive not to bill it.
That's right. That's right. So they all have their own fee schedules, right? So if you go to the doctor to an orthopedic, comp might pay them $100 when Excelis might pay them $150. But if they accept workers' comp, and almost all, especially orthopedics, almost all of them accept workers' comp because a substantial majority, I would think, of their business, or at least a substantial portion of their business, they would lose if they didn't help people that get hurt at work, because that's where so many of us are most of the day and where we do get hurt, unfortunately. So yeah, so the medical bills, your medical portion of the claim includes your right to mileage and travel expenses to and from the doctors, physical therapy, MRI, x-rays. This is less relevant right now, but it does not pay mileage to hearings, to your lawyer, to the pharmacy. It's got to be for medical treatment. And then lost wage payment, they set your average weekly wage at the time of the injury by averaging your earnings for a year. They come up with a weekly wage. They'll pay you 2/3 of that if you're totally disabled from all work. You have to go to the doctor every 3 months, and the doctor has to keep saying a level of disability. Just going to the doctor is not enough if they don't follow.
And Megan, what's the determination? What are the factors that go into partially disabled versus fully disabled?
Good question. So the temporary levels of disability, meaning, just to simplify it, the doctor kind of takes the lead on that. The Workers' Comp Board gives clear standards for what total and partial are when determining permanent levels of disability. They're not so clear on total and partial and how we determine that when you're temporarily disabled, which just means for back injuries, generally it's the first 2 years from following the accident. For limb injuries is generally the first year. So your doctor kind of decides. So comp defines totally disabled only as 100% unable to do any work at all, not just the work you got hurt on. The minute a doctor gives you restrictions, so he can work as long as he doesn't lift over 2 pounds and he's not on his feet for more than 10 minutes, that's still partial in comp. Any restriction is presumed to be accommodatable by someone somewhere. So, so the real basic answer to your question is the doctors kind of take the position. If there's a restriction, you're partial. If you're just plain kept out of work, you cannot work at all, then you're total. So that's lost wages. You have to go to the doctor every 2 months, 2 to 3 months, I should say. The doctor has to keep you out on restrictions. If you're partial, you have to look for work within your restrictions. So the first thing you would do is call your employer, see if they can put you back to work with those restrictions or accommodate them. If they can't, you have an obligation to start looking for work and keeping track of that in writing.
That's where you can apply for unemployment insurance if you are partially disabled on workers' comp.
That's correct. That's correct. And you'd have to, obviously, through the unemployment system, look for work for there as well. So that's right. You'd be entitled to the partial unemployment.
Could you explain, Megan, how the interplay between workers' comp and no fault happens if you're in the course of your employment and you get it and you're driving, you're in a car accident? How does that work?
Sure. So if you're in a car accident and you also happen to be in the course of your employment, you have 2 insurances that are potentially covering you. So you have workers' comp, as I've just described, which is a claim against your employer because that's their obligation, the employer's obligation to cover medical bills and lost wages. But there's also, New York State law requires every vehicle have insurance on it. That insurance is 2 parts. One is liability, right, to cover things that you might have caused, injury to other people. The other is no fault coverage, which covers anybody inside the vehicle who is injured, regardless of whose fault it is. So even if you're at fault driving, or you're a passenger and your driver's at fault, or another driver's at fault, regardless, the insurance on that vehicle covers your medical bills and lost wages. So they have to make sure that you're covered. You know, if you're not in the course of your employment, they got to make sure your medical bills and lost wages are covered. They being the no fault policy. So you would make a claim with the no fault insurance policy on that vehicle that you're in. You would also make a claim in workers' comp. Workers' comp is a first payor, so they always have to pay their medical bills and lost wages first. Comp only covers lost wages up to 2/3 of what you made. No fault guarantees 80%, so no fault would, you can make a claim against no fault to make up the difference. Comp would pay first though, no fault would make up whatever difference there is. You should make those claims timely either way. So if you are—
Yeah, and no fault has even more strict time constraints than, they are much less generous in terms of their procedures than workers' comp, if that seems possible, but they are.
Yeah, it's my understanding that they require more frequent medical treatment too than every 3 months would not do it for no fault. It's my understanding they're every month. You'd have to have certification.
And you have to give, you know, the notice. You have to submit an application, and it's an application that is far more onerous than the C3 within 30 days, or they can cut you off, period.
Right. Yeah, so it's definitely, anytime there's a motor vehicle around, you're in it or on it or near it, you definitely want to find out about both workers' comp and no fault. We can help you with that. So,
well, speaking about going to the doctors and carriers, which I don't know if it's on your list, Megan, but how do IMEs work in the workers' comp system, and what are the client's obligation? And
sure.
That involves a whole—
independent medical.
Yeah, well, they're not really. They're medical exams by hired doctors for the insurance companies. But how does that come into play in your work, and how much of your work does that take up?
A lot, right? So, okay, so independent medical exam, right? Independent only of the claimant. So they are doctors that are hired by the insurance company. So the law says, right, if we're going to say that all these issues like your lost weight, whether your injury was caused by work, whether the diagnosed condition is actually arising out of your job, right? Whether you're totally or partially disabled, the presumption is it's only fair to let both sides have a medical opinion on that. So those are medical questions. Is this diagnosed condition caused by my work? Am I totally disabled or partial? Those are medical questions only a doctor can answer. So both sides need to be able to have their own doctors answer those questions to be protected as a general concept. So the injured worker has his own doctor that he can go to and get those opinions. The carrier, the insurance company responsible, because the employer buys insurance, they have the right to send you to an independent medical exam and a doctor of their choice. You have to go to them. If you don't, the carrier can take the position that they should be able to cut off your payments. That's number one. You know, you can make reasonable changes if they schedule it when you can't be there. They'll give you a notice. You have to call and change it if you have to, which basically you have to go. You're allowed to videotape them and audio tape them if you want, but basically you do have to go. You're also allowed to bring somebody with you. But you have to go to them, and they have to file a report, copy you, the carrier, and your lawyer within 10 days of the exam. If they don't, those exams are precluded. But basically we have a lot of fights, because if your doctor's at total and their doctor says, yeah, you can go back to work as long as he doesn't lift over 10 pounds, that creates a fight over what your level of disability is, which dictates how much you're paid and whether you need to go back to work and what should happen next. So they are
all of these reasons, Megan, are, I mean, today's webinar is educational, but one important piece of the education, one important piece of the story is these are all reasons why you really do need an attorney.
Yeah.
I mean, I listen to it and I go, I can't imagine trying to go it alone on some of this stuff.
No, yeah, I would definitely recommend it, right? So, and we can, it also gives you a lot of peace of mind, so you can navigate this stuff and not, you know, a lot of people get very upset about things that are no problem at all, not upset at all about things that are a huge problem, like skipping independent medical exams. Similar in Social Security, I just had a judge ask a client today why she skipped 3 of the exams. We then pointed out that the Social Security Administration sent them to the wrong address, but these things are critical for both comp and Social Security.
And speaking of a topic we don't discuss very often, but we should, and the clients are out there and the people are out there, how do you get paid in the workers' compensation system?
How do I get paid or how do they get paid?
Well, how do you get paid? How do lawyers get paid? If they hire us, how do we get paid?
Oh, right. So workers' comp controls everything, including us. So a lawyer can never, ever, ever get a check or cash from the client directly. It's illegal. So the only way you get paid is by the insurance company pays the lawyer directly, but they take it out of the claimant's money. So here's how that works. The judge, either at a hearing or at the equivalent to a hearing, which are like proposed decisions, that kind of thing. But basically, the workers' comp board judges make awards. So they verify what periods of time the client's entitled to money, and they will award an attorney fee based on that money. The insurance company pays it, but it comes out of your money. So if I had done $1,000 worth of work and my client's only getting $900, they might give me a fee of $100. So instead of my client getting $900, they would send me $100 and the client would get $800.
And many times it's not reflective of the hours or the actual amount of work you do, is it?
No, it substantially is not. So I'll be working forever. No. But no, it's true that you right. So we have to justify our fees, but it's like the judges almost barely have to look at our bills because we, basically you do an awful lot of work for your $100. My father used to say, do you know what it takes to make $100? And now I do. So the fees are contingency, right? They come out of how much money you get. We absolutely have to justify the fees. So if I happen to walk into a hearing and I just got on the case yesterday and the client's getting a $20,000 schedule loss use award, my fee would normally be about maybe $2,000 to $3,000, and the judge would not even give me that. He would limit based on the work I did. So they will not pay you more, but they will pay you less. But you never have to send
that seems like an equitable deal, Megan.
It is. Actually, it's good for the injured worker because no one has any money at the time these things they need help. So it works. It also kind of forces attorneys to specialize because it doesn't make any sense to do workers' comp unless you're doing a lot of it just as a business point of view. But that serves the client well because then you get somebody that's doing it all the time. And then we can afford to represent people, for 3 or 4 or 5 hearings where we're not getting paid if we have enough business to float everything in the meantime. But yeah, that's how it works. It's contingency. They will never give me a check or cash. We've actually gotten checks in the mail and can't cash them. So.
Yeah, which of course sometimes clients don't understand that when there's a lump sum at the end, which you're going to talk about a little bit, is that they might think you're getting paid too much, but that really is a reflection of all of the work that has been done through the whole case, and still is marginal in terms of the overall work that's been done.
Yeah, that's true. And everybody kind of like the lawyers and the judges understand that. We frequently will be at a hearing where I could get paid, even $150, but my client's only getting, a little bit a week, and that would have to come out of that check, $10 a week. So we'll just waive that. And then in the end, we do get paid. And it's true and that's why when those fees are awarded, we show them all the work we've done because it literally is a payment for that. By the way, often we get that fee. Let's say I get a $3,000 fee today after representing somebody for 4 years, and the claim remains open, and we continue to service it into the future, even though we may not have an opportunity to get paid again in the future. So
I don't understand that, Megan. Explain it again.
That's the way the system works.
So basically, let me tell you really quickly about Permanency Awards. So I'm still on medical bills and lost wages. You get paid weekly, and then eventually the court wants to determine your permanent level of disability for the lost wage section only on any type of injury. If it's a limb injury, meaning arm, hand, leg, foot, it's going to be determined one way. If it's a back injury, it's determined another. The hand, leg, foot, the limb injuries are called schedule losses of use. The spinal injuries are called classification. So if I have a knee injury, schedule loss of use is you go to your doctor, he examines your leg once it's completely reached what they call maximum medical improvement. So once it's healed completely, and they say, okay, you've lost 25% the use of your leg as a result of this injury. That's going to be worth a certain amount of money. There's a way to figure it out in the comp system. They subtract what you previously been paid in lost wages, and they pay you the difference if there is any difference. So if it's worth $30,000 and you've already been paid $10,000 in lost wages, they subtract it, they give you the other 20. That's supposed to be a full valuation of the lost wage section. So you get a check for 20. I might get a fee out of that for $3,000. So you get 17 instead, okay? The medical remains open for the rest of your life. So if you call me in a year and you need another surgery, or you're trying to get your medication filled and they won't fill it, I'm still gonna help you fill that. I'm gonna help you get your next surgery authorized, but you're not getting paid weekly anymore, so there's no way for me to get paid to help you with that. So that's how you could end up continuing to represent someone, but no longer be able to get paid. If they got an increased schedule down the road, you might get a fee out of that, but those are not all that frequent. They happen, but.
Okay, so just to give some framework for this, and then we can get back to your slides and wrap those up, and move on to SSD, but Social Security Disability. If you had to take a gander right now, a guess at how many clients you're continuing to do work on their.
Don't ask this question. A whole
Trying to
lot.
kill me, Angela.
A
No.
whole lot. A whole lot.
Oh, a ton. That's why, I mean, we'll have conversations in our office. How many open files do you have? And you're like, can you ask me a different question? Because it's.
Oh my goodness.
Oh
really?
yeah, I mean,
It's in the thousands. It's in the thousands.
Yeah, I literally have clients I've grown up with. Not kidding.
Oh my gosh, we have to, I mean, just as an aside, you all know, if you're watching this on Facebook, you know that we work together, Joe and I work together, and Megan and everyone in the firm that's on the team to tell the stories, the true stories of the firm. And I don't know that we've ever in 15 years of curating stories have heard, I had no idea that you worked indefinitely on these cases forever and ever for no
you can't,
money.
Yeah, for not getting paid. Yes. That's true. Yes,
yeah,
this
that's
is true.
The nature of it.
I am astaunded. I'm absolutely astounded. Okay.
Yes.
So
Yes,
that's
I'm Mother Teresa with glasses on.
Okay, so I'll turn it back over to you, Megan.
No, it's okay though. It's right. So no, it's good. It's all good. So I kind of covered this already. I won't linger on this, but what I had mentioned when we were talking during the shutdown is there were some nice things going on during the shutdown, which is if you're partially disabled, you normally have to look for work. The board has suspended that. They have not actually said that that is no longer suspended, so that's too many negatives. That's still in place technically, but as far as I'm concerned, for protecting my clients, I'm telling them all, forget that. Start looking for work, because the carrier lawyers and everybody else is going to start pushing on that, and we want to be protected. So you have to look for work if you're partially disabled. During the shutdown also, you have not had to go to the doctor every 3 months. That's being forgiven. That's still kind of being forgiven, but most people, they have to go to the doctor anyway, and they're getting back. But I'm telling everyone now, look for work, get to your doctor, even if it's telemedicine. We already covered this, the permanencies, so I'll move over that. That's just an example of the permanency schedule loss of use. Again, is for limb injuries. And there's a change in law I wanted to tell you about, and it has to do with this. So real briefly, you get a schedule loss of use determination for a limb injury. You get classification for a spinal injury. Classification just sets your right to a payment if you continue to be out of work. The rules changed in 2007. Injuries after March 13th of 07, there's a cap on how long you can get paid if you're classified. The very new case law that came out is the old rule was that you could not get a schedule if you also had a spinal injury involved. And so the carriers were saving money by not paying schedules for people that also had a back injury. There's brand new case law that says that's not fair. So we were able to recap and try to get schedule loss of use awards for you on limb injuries, even where your neck or back is involved. So that's basically it on workers' comp. I can switch over quick to Social Security if you're ready for that.
Okay, yeah, I think that's good. Good. We have lots of different people tuning in and out. No questions yet. So
okay.
Again, we're talking workers' compensation and Social Security disability in particular, as they may have been affected or as we are coming out of lockdown. And we are taking your questions. So if you have any questions for either Megan or Joe, fire away. I'm watching on my cell phone and watching all of you who are joining us. Welcome. And we're going to turn back to Megan now as she's going to walk us through Social Security disability. Oh, Megan, before you go on the SSD, did we want to show that PDF?
Yes, or maybe I'm wondering if we should put it up at the end. So it's the workers' comp board. Basically what that PDF is it tells you all the basics of any comp claim, but it happens to apply to COVID. So if you happen to become ill because of COVID, I didn't really cover that. We have a couple of clients that have who did contract the coronavirus, became ill with COVID-19, and it's our position that they contracted that at work. That is really a pretty straightforward comp claim where you have to prove that it happened at work. So we can put that up, Angela. Do you want me to do that now, or?
Well, why don't we do that now? Or
sure.
Or at the end, either one. It doesn't matter, I guess. Whatever you think.
Yeah, what I'd like, it's very detailed and it goes through what I just said, really the medical bills, how you prove a claim. So I wonder if that might be good, so I don't hold people up. I could get through the Social Security quick and then
okay,
put it all up, because they might want to just have access to that and be able to print it.
Okay,
sounds good. Okay, so just real quick on Social Security disability, there's two types. And can you see my slide? You can see everything, right?
No.
No, we can't see your screen yet.
All right, sorry, what did I do? Let's see. Screen share.
There you go. And then just hit
you can see it now. Okay.
Way over at the left.
Yep, okay.
And
so Social Security disability, I covered this before, but I'll do it quick again. There's two types of disability-based Social Security. One is called Supplemental Security Income. Everybody calls it SSI. The other one is called Disability Insurance Benefits, but most people call that SSD. So when I say Disability Insurance Benefits, that's what the Social Security Administration, they actually call it. Both of these benefits are disability-based, meaning you have to be disabled to get them. What do they cover? They give you a monthly payment and they give you a medical insurance. So SSI is need-based. What you get monthly is a payment per month. That number, 783, is what the federal government pays. But in New York State, you'd get about 810 because New York State supplements it, okay? So basically you get a monthly check and you get Medicaid if you're eligible for SSI, Supplemental Security Income. If you're eligible for SSD, which again is disability insurance benefits, you get a monthly payment that's based on your earnings at work, how much you paid in by being taxed, and you get Medicare, okay? Although there's a 2-year waiting period for the Medicare. SSI is a need-based benefit. So what I'm going to tell you is both of these benefits have two basic requirements. The first requirement is financial. The second requirement is a level of disability you have to prove. The first requirement is different between the two. The second requirement is identically the same between the two. So supplemental security income, again, it's need-based. So what they look at is your financials, the financial requirements. They look at your resources, they call them. So you cannot have more than $2,000 a year in countable resources. So they only exempt your house and your first vehicle primarily, and then they exempt a few other things. But assume they don't exempt anything except your house and your first car. After that, you cannot have savings accounts, you can't have stocks, you can't have a life insurance policy, you can't have a camper, you can't have a snowmobile, anything that's worth more than the threshold. So this is a very much a need-based benefit. For an individual, it's $2,000, for a couple, it's $3,000. If you do, so when you call it to get Social Security disability, you call the 1-800 number, or we apply for you online. The first thing Social Security does is to see do you even qualify financially? If you don't, there's no point in them going on to try to figure out if you're disabled or not. And that's with regard to SSI, okay? So first you have to meet the financial requirements. Second, you have to prove you're disabled. For Social Security disability, the financial requirement is not need-based, so you could win the lottery and still be eligible, provided you have enough credits. So credits means you've worked long enough and you pay, if you work anywhere that it's not under the table, Social Security, a huge part of your tax being taken out of your paycheck every week is a Social Security tax. It's 7.5% that you are paying. And then your employer is also paying 7.5% on their taxes. So 14% of your income is going to the federal government for Social Security. That's why you should not feel guilty about claiming it, because they have all your money. So anyway, if you have enough credit, so if you're an adult that's over about 28 years old, you have to have basically 10 years worth of work. There's 4 credits a year, 1 for every quarter available. You can get 4 credits, just, you don't have to work in every month of the quarters, but you have to make, right now you have to make like $5,000 gross a year and you get a full 4 credits. Once you have 40, you are what they call insured to be considered for Social Security disability should you ever become disabled. That's why they call it disability insurance benefits. Okay, so when you call into Social Security and you say, I want to apply for disability, they're going to look at you both for SSI and SSD. They're going to see if you're financially eligible for SSI. They're going to see if you have enough credits to apply for SSD. If either one of those you don't apply, you don't meet the standard financially, they'll send you a letter very quickly that says you don't have enough credits, so you're denied for SSD, or you have too many assets, so you're denied for SSI. If you happen to meet either one of the criteria for the financial, they'll move on and try to figure out if you're disabled. So what we do for you is specialize in proving that you are disabled, which is not easy at all, okay? It's frustratingly difficult. So the disability standard, here's what they do. I have on here, okay, so they categorize all work based on Labor Department standards: heavy, medium, light, sedentary, skilled, and unskilled. The first thing they want to know from you is what you have done in the last, they call it past relevant work. Any work you've done full-time for more than about 3 to 6 months in the last 15 years, the judge has to figure, the Social Security has to figure out what category of work is that. Is it heavy and unskilled? Is it medium and skilled? Is it sedentary? Then they look at your conditions, your diagnosed conditions, and they want to know if the conditions are not enough, diagnosed conditions. You have to have diagnosed conditions that cause limitations that render you unable to do the category of work that you have done, okay? If you're 55 and over, allegedly it's easier because you only have to prove that you can't do what you used to do. So if I have a mason that has done masonry work for, X number of years, more than 15 years, and he's 56 years old and he had a fusion surgery in his back and he can't lift over 10 pounds anymore, I can prove that he cannot do his past relevant work. Why? Because he can't do heavy labor. However, they're always going to look at that guy and say, does he have transferable work skills? If he does, they may not say he's automatically eligible. They may say, well, wait a minute, could he transfer those skills in some other line of work that's lighter? So that's kind of the analysis they do. If you're 55 and over, it definitely is easier. 54 and younger, you don't get that presumption, although I will say 50 to 55, we can argue so 55 and over, they say is advanced age. How do you like that?
Yeah, that doesn't make sense.
No, they've never changed it, which is beneficial to us, but it certainly seems young to me. 50 to 55 is approaching advanced age. So we can kind of make the same arguments for people that are approaching advanced age. If you're under 50, it's substantially harder. So that's like, I guess I've given you kind of a really quick synopsis of it. The big thing I want people to know is this. Number one, it is difficult to prove. The judges the better the economy, the more jobs are available. This is all the unsaid things. I swear the tougher the judges are. I've done several hearings in the last week that are people you should think for sure are eligible, and these judges are talking to them like, why are you even asking? So the big things that we have to prove and that we have to prove are not just what is wrong and what you're being treated for, but how, in a very specific way, are those affecting your ability? Are they affecting your ability to stand, sit at one time, total in an 8-hour day? How much you can lift occasionally, frequently, and constantly? All these real detailed things. What we do we have to have medical opinions on that, not just what you say is wrong and what you say you can do. So what we do is there's these forms that we ask your doctor to fill out, and they're the most important thing. We call them medical source statements. And they're literally created right out of what the judge has to decide. The judge has to have medical evidence to support what he finds on these details. You can give him a stack of medicals 6 feet high and he'll never find how much you can lift unless you're trying to go back to work, right? So he'll never find how long you can sit. So there's details that we really push our clients to help us and push their doctors to help us get executed so that we can try to actually prove the case for you and get it for you and get the money that you've paid in your whole life
So
back.
it's not, Megan, have you dealt with clients who've tried to initially do some of this on their own, and then they get into the pipeline and the process of this, and then they say they're overwhelmed with the paperwork, or
Yes.
they don't understand, or
Oh, yeah, I have two right now that we just did hearings, and we may or may not win those hearings strictly because they came to us so late. Like they went through the whole process. They get a hearing notice and they call you, right? So now we have about maybe 4 to 6 weeks. Now we can run around and get all your medical records maybe in that period of time, but we can't get those medical source statements filled out because usually it takes 2 or 3 tries. The client has to bring it with them to their doctor. They have to ask them to please fill it out. The doctor takes it and says, sure, I'll get it to your lawyer. And then we never hear again. Nobody knows whether they're wrong or we're wrong. So yeah, you've got to get to us early because I spend a lot of my time explaining to people how it could possibly be that they're losing when they're as disabled as they are and they know people that have it. And so the answer is what you have to prove is so specific, and you have to have medical evidence to support that we have to stand on our heads to get that for you.
Right, it's such an in-depth, detailed process that if you skip those steps, you're out of luck. We do have a question, Megan, from Kevin. What age does SSA? No, he's saying SSA, so I'm thinking
Social Security Administration. He might mean. So yeah.
What age does the SSA use? The age of when you go out of work, or when you go in front of a?
Yeah, that's a good question. That's a good question. So they use both, right? So when you're sitting in front of them, you might be 56 or 55. When you applied, you were 53. So a judge could actually, I've had judges find a person eligible on their 55th birthday, right? So in other words, they will say, okay, I know you applied and said you're disabled retro to 2 years ago, right? When you were 52 or 53 or 54. But I don't, in other words, the standard changes when you're 55. So I don't think you had enough evidence between the ages of 53 and 55, but I think because the standard's a little easier, I'm going to say you meet it at 55. So the answer is you can still apply if you think you're eligible, and we will make that argument, but the judge is making a decision about your eligibility today and back to the day you applied and 1 year prior to that. So all those ages are relevant.
Now, Megan, we talked earlier about attorneys who are very specific and versed in workers' comp. What about the judges? Like when you're saying these judges and they're looking at these cases, the SSI cases and even the workers' comp cases, who are these people? What are their backgrounds typically? What have you found with as long as you've been in it? Where do these folks come from, and why do they choose this line of adjudication?
Right. So there's a lot of answers to that one. I mean, I don't want to I don't want to speak to their motivations, but I could guess. But so let me tell you about Social Security first of all. There's a lot of Social Security judges that have not been doing it very long. There's also a lot of them that I don't know whether they've been doing Social Security at all prior to that. But Social Security, the procedural rules that govern those judges, they have to write decisions, or somebody has to write them for them. But a decision has to be written that they can't just say, I find him eligible, and throw in a couple things that they relied on. They actually are required to go through this 5-step sequential evaluation process and make findings on every single detail and point to the medical that they relied on. Okay, so this works to our advantage in a way. So they try to make it like a formal process that each judge has to follow, so that you don't just get, the whim of the judge when you go in front of them, whether you get a proclaimant guy, you get a guy who doesn't think Social Security is a good thing. They're trying to quantify it. Anyway, but because those judges have to point to this medical that they rely on, they overwork them. They have a whole bunch of hearings on, and they're annoyed if I don't hand them and point to them what the medical is that I'm relying on that says you can't lift or you can't stand or you can't walk. So if I can get those medical source statements, I hate to say the same thing over and over, they love us if we can do that for them, because our goal is to write their decision for them because they're overworked, and right. So the judges, maybe they've only been around 5 or 6 years. Most of them are lawyers that have been practicing for a long time, but not necessarily Social Security, because there's some retirement benefits that are probably motivating them. But yeah, they got to go through it. I can tell you what they we can go through the decision ahead of time, and I can tell you what they're going to have to decide and what we have to present to them and where the holes are in our case and in their decision.
So that's all the strategy, right, Megan?
Yeah.
That's the backroom strategy, is really looking at it almost like a chess game and understanding look, the easier and more streamlined we have this for this judge, the better, the better likelihood of us getting a decision in our favor.
Right, and it actually makes it easier for the judge too, because they're, if they feel bad about it, they can look at you and say, sorry, I would do it for you, but you have not given me what I need. The workers' comp judges, they have more, those judges, many more of them have been doing it a long time. A lot of them are very competent at comp. They know the system, but their hands are tied a lot too, based on the appeal court right now. The board that oversees and makes decisions on appeals, I would, in my estimation, are not. They're very pro-employer, anti-claimant, in my opinion, at this point. They didn't always be. They used to be the opposite. So the judges are good and competent and predictable because their system too is kind of controls them. But we know there's only a handful of them. We work in front of them all the time. We know what they're going to require. We even know how long they're going to take in their hearing. We know what they're going to say when they start. We know everything about them. So.
Well, I mean, to a large degree, Megan, this speaks, does it not? And Joe, you can probably speak to this too. I mean, there's a couple of points here. And Megan, is this your last slide?
It is.
It is. Maybe take it off then, hun, so that we can, there's some good.
Yeah, that just gives you the phone numbers and the, that kind of thing, but you can just call us and we can help you with it.
Okay. Yeah, and then we can see your face.
Yeah.
But this speaks to, if you're dealing with if you don't want to go it alone, and you turn to a general practice lawyer who really, he or she is kind of doing a little bit of everything. Workers' comp is tagged on there somewhere as a little bullet point, right? In like the 8-point font down at the bottom of their business card. That's a risky proposition, is it not?
It is, and in fact, most lawyers are, even if they do that a little, they're going to bail out of that pretty quickly because, it's not, you don't have to be brilliant, but you have to know it. You have to do it.
Well, and not only to what you said earlier, Megan, I mean, theoretically, you're leaving this door open for a long time. And unless you're doing just this focused kind of work, you can't make business sense. You have to be working on a volume basis. Yeah,
definitely. And the other thing I've learned as I'm getting older is that, the longer you do it, the I don't know, isn't there an old adage that until you've done something 25 years, all of a sudden you realize everything you didn't know for I don't even know how many years, but yeah, I mean, it's led me to say, I'm not going to touch things I don't do. And I would not recommend you go to somebody who is willing to touch things that they don't do. Yeah. And I think even under this COVID and now that everything's getting more virtual, some of the crutches that people used to use, like lawyers would come in and them by sight that they don't do it, okay? They would come over and ask you questions. You can't do that anymore. What are you gonna do? You're gonna call, you know what I mean? You can't.
Right, you're sitting on a Zoom. What are you gonna do?
Yeah, and I would help them and I would say, don't do that.
Here.
Yeah, exactly. I would say, you don't wanna do that. Do this or ask for this. I don't mind.
Wait a minute. So that I'm clear and so that our viewers are clear. In the midst of a case, you could have another attorney who really doesn't know what they're doing come over and ask you what to do or get some input.
Right, so I'm talking about like just as a professional courtesy, if somebody had a hearing about to be called, not my client, right?
Yes, right.
Somebody else's client, and they would come over and say, let me just ask you a question. How is this handled? It's not because I'm brilliant, right? It's because we've all done it. And you even see young lawyers more from the carrier side that, you get in an ethical dilemma because you have to, and I'm not trying to sound like I'm smart, right? But you just do it. So you've done it forever. It's like any business. They will propose something that has a secondary effect that is going to hurt their client. And you're supposed to zealously represent your client, but they're about to make an error, right? I just had a conversation with another lawyer who's about my age and been doing it just as long. And what do you do? And by the way, lawyers are getting, like everybody else, a little less ethical. Because this young lawyer said, younger than I am, but not young, said, absolutely, you don't tell her that. You just do it. And let her get fired from her client, right? I don't know. That's a totally different issue, but it's just part of any business, I think. People got to learn it, and so they have to ask questions. But you're in a vacuum now. So unless you have somebody to help you in your bedroom, who's going to help you at this point?
Well, and I'm going to turn this over to Joe from here, and thank you, Megan. And you can both, of course, speak to this, but we've touched upon this before, is that it's vitally important if you potentially have a personal injury case, and there are people who have workers' comp cases who don't realize that there's a secondary case there, right? Or vice versa. And you really, it's really important that you explore that as a, is that an option? Is it relevant for you? And if it is, you darn better be sure you've got the left hand speaking to the right hand in,
You know, I even,
claim.
honestly, I won't even touch what Joe does. Like in the office, I won't, people will ask me very basic questions and I will say, I know the answer, I think, but I'm not answering it. I'm going to make Joe answer it, or I'm going to make one of his attorneys that specialize in personal injury answer it, because everyone, including me, if you go into any area that you don't specialize in, you don't even know what you don't know, you know? So
right.
I mean, I think I go on the, I do it to the extreme, but I think it's a good way to protect your client and make sure that they get exactly what they need.
Joe, from your perspective, can you speak to that?
That's a good lawyer who knows what he doesn't know. And
Yeah.
actually, it's a very important thing. And so yeah, we start out at the beginning. That's why we ask so many questions about everything, because you have to drill down deeply to figure it out, and then you have to verify it. Our cases are fact specific, medical specific, so we take information in, but one has to take it all with perspective and verify, and then put it in where it needs to go in the legal framework, which that all is part of a big story that may sound simple in the words I'm saying, but gets very intricate and complicated and can take forever and take very many twisted turns depending on what you find, both medically and factually about how things happen.
Well, that's what, can you think of a true story, a case from the past where there was a circumstance where there was both a workers' comp as well as a PI case, and as an example of how the team, you know, you're aware of one another, but you're staying in your own lanes at the same time? Or Megan?
I can give you an example right now, if I don't mean to jump in. This is just this isn't a big case, but just a simple thing. Joe's partner, Rob, sent an email the other day that said something about taxi drivers and make sure that you ask X because the threshold does not apply, okay? I've been a lawyer for 4,000 years and I did not know that, right? So if you don't practice it, you don't necessarily run into these things. You don't have a reason to research it. So you see what I'm saying? So I'm like, that's why I'm gonna ask Rob, I'm gonna ask Joe, I'm gonna ask Stephanie, I'm gonna ask because you don't know what you don't know, right? It's the experience in that field that's going to give it to you, and it's not the law degree. So you don't just go to a lawyer and say, "This, you know, my cousin is a lawyer. He got a law degree. That's great, but what does he do?" Right? It's like, yeah. So I don't know. It's a simple thing, but it just reminded me that you never should let that guard down and think you know everything, because you're doing well in what you do.
In what you do, right?
Right.
Right. All right, any added thoughts, Joe or Megan, with respect to as the offices are opening, as the courts are potentially reopening, as things are slowly coming back up to some kind of momentum? Are there things that, you know, you're...
I have a thought. The thought is that, thank you, Megan, by the way, you did a fabulous job as usual. But just remember, now we're all getting back to work, especially if you've been home for a while. Every job involves safety. It all involves procedures, and going back, if you haven't done something for weeks or months, you may not be operating at the optimal level of safety. You have to relearn your job, just like we relearn how to drive in the snow every time we get a first snowfall. So remember, it doesn't take, muscle memory doesn't take long, or brain memory doesn't take long sometimes to forget about safety or just how you do your job efficiently. So remember, when you get back going slowly, do things carefully, reacquaint yourself with how you do things so that you don't need to call us. Because remember, when you have to call us, it means that something bad has happened to you. And really, if you can avoid it, you absolutely should.
Now, Joe, this is a great question. As people start to go back to work and integrate with their colleagues and their employers, just as I know this is an aside, but what's the next step that they do if they have viable concerns about potential not social distancing adherences or certain safety protocols being accurately put in place? Can
Well,
you just recap there?
yeah, well, the answer is that every employer is supposed to certify they're meeting New York State standards. We ourselves, we have a whole bunch of procedures that we have in place. We had to fill out the state form and certify that we're meeting social distancing, wearing masks, et cetera, et cetera. All employers are supposed to do that. We're all supposed to work together so we keep us all safe, so we don't have these spikes, so we can keep opening more, so that we get through this mess. Because if we are sloppy about it, or if we're cavalier, we're hurting others besides ourselves. And you're ultimately going to hurt yourself if this whole thing crashes back in our laps. So if your employer's not, I suggest, first of all, saying to whoever is supposed to be doing it, hey, why aren't we doing this? And then there's a state agency you can complain to about complying with these reopening procedures. You know how that always works, though. The squeaky wheel might get the boot, so to speak, because you may. So it's problematic if you're afraid for your health, or then are you afraid for your job? That should be that way, but we all know how sometimes things work.
Well, it's a reality, you know, and hopefully COVID is not here for forever, and you know, it's not like
That same scenario still works. If you complain about unsafe conditions, whether it's COVID or other things, it's usually the same employers that aren't safe about some things are not going to be safe about COVID, and that is going to be the problem.
Mm-hmm.
All right. Well, in any case, if anyone has a workers' compensation question, if you have a Social Security or supplemental benefits, any questions relating to anything that Attorney Megan Fallon has shared here with us so graciously today, for your time. Thanks, Megan.
Sure.
I always learned something, and there was a comment on here. Megan is so smart.
Oh,
And,
good. That was probably my mother.
No, it wasn't.
But she can't use Facebook.
And I
Thank
said,
you.
yes, she is. And not only are you smart, you're a gem of a human being. So, and I
Thank
think
you. Oh my gosh. Thank you.
bulk of your clients can attest so too. And you know, Joe has some pretty, you know, tough criteria for people he likes to surround himself with sometimes.
Yes.
You know, I think he can, you know, he sings your praises pretty loudly and deservedly so. So with that, StanleyLawOffices.com is the website. We are actually in the process of designing a whole brand new website for those of you out there. It'll still be a few weeks before it'll be out, but keep watching and that'll be exciting. You can certainly call the office anytime at 1-800-608-3333.
And one thing I forgot, our July 7th, we're going to have another webinar with healthcare providers. So this will be very interesting. We'll be promoting this in great detail. We're going to have an acupuncturist, a chiropractor, and a physical therapist come in and have them tell you about what they do and how they handle work injuries and accident injuries, and the process, and how they can help you get better, and how they help you get through the system in terms of documenting your injury, whether you have a personal injury case, comp case, or Social Security disability case.
Yeah, great.
Yeah, that is awesome. It's going to be really beneficial and interesting to meet these people. So 1-800-608-3333. You know that we have offices in Syracuse, where the home base is, and also in Watertown, Binghamton, Rochester, and Montrose, Pennsylvania. And you can reach out to us as well via Facebook anytime. We check our messages there daily. And you can email Megan. What is your email address, love?
It is M. Fallon. So M as in Mary, F as in Frank, ALLON at StanleyLawOffices.com.
And you can email, you all know you can email Joe at joe@StanleyLawOffices.com. And Joe, I saw another one from Lance today. You're doing your radio interviews and your television interviews, and all of that is still going. And we've done a lot of stuff virtually over the last few months, but have managed so. So July 7th, we'll be back here. And thank you again for those of you who watched today, and for the hundreds, if not thousands of you who will tune into this in the archives beyond today. Stay well, be safe, be smart, Be your own best advocate, right? What is your saying, Joe? An ounce of prevention is worth a pound of cure.
That is so true.
Yeah.
Mhm.
All right. All right. Thank you all. Take
All
care.
right, thank you.
Bye-bye.
Bye.